Good morning, and thank you for appearing today via Zoom. On behalf of Judge Carr and Judge Sutton, we want to thank you for that. Today's date is February 15th, 2022, and you are the only oral argument that we have scheduled for today, so each of you will have 15 minutes to present your arguments. Of course, the appellant may reserve up to 5 minutes for rebuttal. I'll be presiding, so I'll be keeping track of the time. If you are going to reserve time, let me know, and I'll try to let you know as you get close to your rebuttal time. The oral arguments are being recorded and posted on the court's YouTube channel. So if you're not making your argument, if you could please mute yourself so that the background noise is reduced. We typically indicate that if there are children or victims involved, we don't use their names, just use initials or whatever. That doesn't apply in your case, but as a public service announcement, I suppose, since we're being taped, we'll mention that. Judge Carr, Judge Sutton, and I have read your briefs, and we are prepared to proceed if you are. So let me start by asking the appellant, will you want to reserve some time for rebuttal?
Yes, Your Honor. I think 2 minutes.
2 minutes. All right. I'll let you know as you get close. All right. You may begin. Thank you.
Thank you, Your Honor. If it please the court, my name is Kathleen St. John. I am counsel for the appellant, Antonio Perez Herrera, aka Paul Lujan. The issue before the court today is whether a pharmacy owes a duty to a patient who arrives to claim a prescription that will be called in but has not yet been called in. And we respectfully submit that the pharmacy does owe such a duty. It is a narrow duty, basically, to take down the patient's information and to offer to enroll him in the callback system so that when the prescription does come in, he can either get a call or a text notifying him. Basically, this duty is consistent with what the pharmacy currently does. It's consistent with what our expert testifies as the standard of care, and it is consistent with the Ohio Administrative Code provision that requires pharmacies in the state of Ohio to have a system for entering patient profiles. So I'd basically like to discuss the duty issue in terms of 3 categories: the special or definite relationship between the plaintiff and the defendant, the foreseeability, and the public policy concerns. So starting with the definite relationship, as the trial court indicated, when you're talking about nonfeasance, as in this case, you need a special or a definite relationship in order to impose a duty on the defendant. Now here, as I've already previewed, the definite relationship, the record and the evidence in this case shows that there certainly is a basis for saying that there is a definite relationship here. Starting with the existing policy and protocol at the Walmart pharmacy, we have an amazing record here of testimony by the pharmacy manager as well as some of the pharmacy technicians indicating that they are trained that if a patient like Mr. Perez Herrera appears at the pharmacy to claim a prescription that hasn't been called in, they know it's very important to get that individual down to the drop-off window so that a profile can be created and to offer to enroll him in the callback system so he can get this call or text. And that isn't an optional a responsibility of the technician. It's something that they're expected to do. And as the pharmacy manager testified in this case, if they don't do that, they have not done their job. And that, of course, is what happened here. And we know that both because of Mr. Perez Herrera's testimony, as well as the testimony of the one pharmacy tech who was on duty that morning, Ms. Schlemmer, who testified that she doesn't like to work the windows. She'd rather be in the back filling prescriptions. And if a customer comes, she'll just say, it's not here. So she didn't do her job. And that's the first good reason. The existence of the protocol is the first good reason why there is an acknowledged relationship here. The second reason, of course, is our expert's testimony who says this is the industry standard. And we've cited cases. Granted, they're out-of-state cases, but we're all grasping at out-of-state cases because of this is essentially a case of first impression in Ohio. But I would cite this court to the Correa case out of the Supreme Court of Massachusetts, where the court said a duty may be created by the company's internal policies as well as by industry practices and policy considerations for the industry as a whole. And also the Happel case out of the Supreme Court of Illinois also recognizes that industry protocols or the existing practices of the pharmacy can show that there's that kind of relationship. And then the third consideration here, so we have the existing protocol, we have our expert's testimony, and by the way, we are the only party in this case who had an expert pharmacist testifying about what the standard of care is. And she's a pharmacist with 30 years experience. She owns 2 outpatient pharmacies. She teaches pharmacy to pharmacy students. So she is highly competent to testify about what goes on in the industry. Then the third kind of indicia of why this policy exists is the Ohio Administrative Code provision, which was actually cited by Walmart, but it is the provision that requires all pharmacies in the state of Ohio to have a patient profile system that would include the telephone number of the patient. Now, Walmart contends that this only applies to customers who have a prescription already there at the pharmacy. But how can the pharmacy adhere to its duty when the prescription is actually called in if they don't get the customer's information when he arrives to claim the prescription? So,
Counsel, let me ask you, this is a very fascinating and tragic case. I know that the existence of duty is an issue of law, and I think you both agree on that. However, do some facts maybe influence that issue of law? In other words, are there any facts in dispute here in regard to what happened? For instance, I don't recall right now, but I don't think the evidence was that Walmart asked him to come back. Was there any evidence, for instance, of that? We don't have a prescription for you, check back later.
You're right, Your Honor. There is no evidence of that. Mr. Perez Herrera said the technician did not suggest that. And additionally, he didn't think of it. And with respect to the testimony of the Walmart employees, because they were testifying a couple of years after this incident happened, everybody is basically testifying based on their habit and custom and practice. None of those employees had a memory of this situation. And of course, there's no written record. So we basically know just from Mr. Perez Herrera's testimony.
Although he did indicate when he was told that there was no prescription, that a prescription was called, or he was prescribed medicine and told to pick it up at that location. Isn't that true?
Oh, absolutely. Absolutely. Yeah. He went there and he told the technician that I'm here because I was told there's a prescription for me. And when she said there's nothing here, he said, I don't understand. I was told that there's a prescription. And she looks again and she says, sorry, there's nothing here for you. So she doesn't say, I mean, at the very least, she could have said, well, maybe you should check back later. That's not even what their policy is. Their policy is send the man down to the other window to get a profile built. But she doesn't even do the absolute bare minimum of suggesting that he try back later. And,
Counsel, I know that there may be an issue as to whether your client is proficient or not in English. I know it's not his first language. Was there any evidence? You said nobody really remembered, so there wasn't any evidence that they couldn't understand him or anything.
No, there was not evidence that they couldn't understand him. And my understanding is he must have said enough to get his message across. And the testimony from the pharmacy personnel was that if they do have a Hispanic speaking individual, not only do they have the translation service available, but he can do something as simple as showing them his card, and he did have a card identifying himself. So I don't think it's disputed that he didn't get his message across that he was there for a prescription, certainly according to his testimony.
Thank you.
And I just have one more thing, and I hate to interrupt your argument, but can you be very specific as to what the rule of law would be coming out of this case if we were to fold in your favor?
Well, I think the rule of law would be that there is a special relationship between a pharmacy and an individual who comes to pick up a prescription that has not been called in, such that the pharmacy has a duty to basically adhere to the code provision. If you create a patient profile and you offer to enroll them in the callback system so that when the prescription is in, they can be contacted. It would be just that simple. And, the interesting thing is, once that prescription was called in, and it was called in about an hour and 20 minutes after he had arrived there, he is a patient, he is a customer. Even Walmart would agree with that, because there's no dispute in this case that pharmacies do owe duties to their customers who have a prescription. So he actually does, even under Walmart's interpretation, become an individual to whom a duty is owed. The question here is a temporal one. At what point in time can we say that there's a duty owed? And that's why we say it's a narrow duty, because until the prescription comes in, all we're asking is get enough information so that you can notify him.
Thank you. You have about 2 more minutes before you get into your rebuttal, just to let you know.
Okay, then I think I should probably reserve my rebuttal. I do just want to make one statement about public policy, because I think this is really important. The trial court, in addition to thinking that this was some sort of a major burden, which it is not when you've already got an existing policy, but the trial court also felt that the burden was best imposed on the customer. And all I have to say to that is comparative fault. We're in an era of comparative fault. Putting the burden on the pharmacy still doesn't get the customer off the hook. The question of their negligence and the apportionment of that fault still goes to a jury. So I'll reserve the remainder of my time.
All right, and that would be 3 minutes.
Thank you.
All right, very good. All right, Counsel, you may begin when you're ready.
Good morning, and may it please the court. I'm Matt Blickensterfer on behalf of the Appellees Walmart Inc. and Walmart Superstores East LP. Mr. Perez Herrera asked this court to establish a first in the nation affirmative duty to act on behalf of someone who is not yet a customer of a pharmacy. In essence, his argument is, Your Honors, that simply by showing up at a pharmacy, someone can create a duty for that pharmacy. And as it's been articulated, it's a duty that depends on occurrence of some event in the future that is not known at the time to the pharmacy. Your Honors, that can't be right. Pharmacies cannot have duties that are based on something that may or may not occur in the future. And there is testimony in this record that it is not unusual for someone to show up at a pharmacy thinking they have a prescription there and that they don't for one reason or another.
Counsel, can I interrupt?
Absolutely, Judge Carter.
In regard to, I guess you refer to them as customers, as a pharmacy customer relationship. Is that what you say, or quad or a pharmacy patient? It
Yeah,
just seems weird to call it customer for a pharmacist.
Yeah, they're certainly patients with respect to immunizations and prescription drugs and things like that. It's, they maybe, customer may be a better word for something, that's over the counter or something like that, Your Honor. But no doubt, as a matter of terminology, once they have a prescription from the pharmacy and it's being dispensed, certainly they're a patient as well as a customer.
Okay. The only reason I was asking that is because both of you refer to him as a customer and sometimes as a patient. So I just wanted to make sure I had the right terminology that everybody agreed to.
Yeah, nothing at all intended by that terminology.
No, I'm not suggesting it was. But in regard to that pharmacist patient duty, then I guess what I'm wondering is, you see him as a potential patient or somebody that is, your argument is he's only a potential patient, and so there's no duty owed to him. But I guess what I'm wondering is, isn't he in a little more of a special category, because he's not just coming in and saying, like in the one case, hey, I'd like to have some medicine. Can you give me some from behind the counter? He's saying, I have medicine that my doctor has called into you. So that in and of itself seems to establish a little bit more than just a prospective patient or prospective customer coming in.
Again, I would agree it's different in some respects, Judge Carr, but again, we're looking at a situation at the time of what's occurring at the time, and from the perspective of the pharmacy, and this has to be from the perspective of the pharmacy because we're talking about imposing a duty on the pharmacy. And the perspective of the pharmacy at that time is they do not have a valid prescription called in for this person. That somebody can show up at a pharmacy and think they have a prescription and they don't, because it's at a different pharmacy, or they could have misunderstood the doctor, or there are, a dozen reasons why someone might show up at the pharmacy expecting to pick up a prescription and the pharmacy doesn't have it. So in those situations, the pharmacy can't know. Certainly in this circumstance, the facts of this case, the pharmacy had almost nothing to go on other than Mr. Perez Herrera indicating he was supposed to have a prescription here. So again, Your Honor, we're talking about a duty imposed on a pharmacy, and we can only impose that duty reasonably based on what information is available to the pharmacy at the time, and whether or
Counsel,
not.
but I'm sorry for interrupting. It's just
This
that
is
it's such.
for you, Your Honor.
Yeah, I know. It's just only 15 minutes, and unfortunately or fortunately, one of the two, I have a lot of questions. Okay, so you say the pharmacy doesn't know anything about him, and I think, isn't that the essence of what the other side is arguing? You didn't attempt to know anything about him. At least he could have gotten a phone number. If you had his name, at least you could have gotten a phone number, or told him, hey, check back, give me your phone number, check back. If you don't hear from us, check back in a couple hours.
Yeah, Your Honor, there is no doubt that we could rattle off 10 or 12 things in this horrible set of events that if one of them, if only one of them had gone differently, this really horrific result might have been averted. And yes, one or two of those things could have occurred at the pharmacy interaction. But that's different from saying the pharmacy, and every pharmacy in Ohio has an obligation to act affirmatively merely because someone set foot in the pharmacy and says, I have a prescription here.
Well, I'm going to add to those special facts. I got the impression from the briefs that when Mr. Herrera showed up, he was in excruciating pain. It'd been over the weekend since he had gotten the prescription, or since he had gotten the injury, and his pain had advanced. I don't know what the record shows now. I'll have to take a look at the record. But is there anything in the record that would indicate the amount of pain? Was it obvious to the Walmart pharmacist or employee that he was in excruciating pain, for instance?
Yeah,
Might that be another special fact in this case?
Yeah, I don't think it is under these circumstances, Your Honor, and this is why. And Ms. St. John can, correct me if I get anything wrong here in her rebuttal, but I believe what the record reflects with respect to that is that he testified that he was in pain, his back hurt while he was at the clinic and throughout the rest of the time, but that he never reported that to anyone, that his back hurt. Including the physician assistant who treated him. So, and there's no evidence that I'm aware of in the record indicating that any of that was manifest to anyone other than himself. And his testimony was relatively clear that he never reported that back pain to anyone else. So again, Your Honor, we're back to a situation where, a pharmacy that's busy on a Saturday morning. He testified that he was sixth in line and the pharmacy was pretty well staffed with multiple employees at the time. Busy pharmacy, doesn't have his prescription. He doesn't know what his medicine is. There's just no way for the pharmacy to, draw any inferences about that.
Counsel, could you
Yes,
speak to the issue, because some of the things that you're raising are points about the gentleman who came in. Can you speak to the issue of comparative fault then? Because those might go to that.
I'm glad you raised that because I took a note on that. I think that argument sort of sounds appealing on a very superficial level, but ultimately, I don't think it's how tort law works at all. We don't get to a notion of comparative fault until we assess as a matter of law, there is a duty. You can't conflate those two things, because if you do, suddenly every situation in the world becomes a question of comparative fault. If I step away from this podium right here and trip and hit my head on the way out of the room, the first question is whether this court owes me a duty for having brought me to this position. Not, well, I'm 99% at fault and maybe the court's 1% at fault. That's not how tort law works. There has to be a duty in the first instance, and we don't we just skim past the duty question, say, okay, Walmart could have done something here, so we'll give them a few percentage points of fault. That's not how tort law.
So going back to the duty, when precisely is it, what is your position about when the duty attached?
When the pharmacy receives a valid prescription, Your Honor, that the plaintiff treats this as just a timing question. And under the facts of this circumstance, these events, the interaction and the receipt of the prescription are close in time. That is true. But
I'm sorry, counsel, just because I know we're running out of time. So what is the duty when that occurs, when that prescription is called in? What is the duty?
The basic duty, the most basic duty is the timely, accurate fulfillment of the valid prescription that is received, which in fact occurred here. There's no doubt, there's no dispute on the facts here that once Walmart got the prescription, it filled it. There's no dispute about its accuracy. It was there remaining for 10 days for pickup by Mr. Perez Herrera. There certainly could be other duties associated with the pharmacist's job when that valid prescription is received, Judge Sutton. A lot of times there may be a duty to consult with the patient, perhaps, that is prescribed by regulations, things of that nature. But the basic duty is to fill the prescription timely and accurately. And this receipt of a valid prescription is far more than just some sort of timing event. It's of significant legal consequence in the pharmacy industry. In many cases, a pharmacy cannot act without a valid prescription. So it's more than just passage of time we're talking about. They have to have the valid prescription.
Are you suggesting they can't act even to the extent of creating a patient profile?
I'm not suggesting that they couldn't do it voluntarily. I'm just suggesting there's no duty to do it. And I'm not out on a limb in suggesting that, Your Honor. We have no case law at all to suggest anywhere in the country as best as the parties could ascertain. Nobody cited anything with respect to a potential patient or potential customer imposing a duty on a pharmacy to sign them up for a callback system or something. Which
the counsel, that could be as simple as every pharmacist and pharmacy assistant does that as a matter of course. That could be the reason you don't have case law on it, because that's just a matter of standard practice. Isn't that maybe an argument to your present or your submission to us today?
I don't think so, Judge Carr. And one indicator, I mean, first of all, if that were true, surely at some point in the millennia of apothecaries and pharmacists, we would have a case somewhere along those lines. The other thing that I think is important here on your point, Judge Carr, is this is a heavily regulated industry. It has been thoroughly and carefully regulated both by statute and by regulation. And of course, there is an agency that deals with pharmacy regulation. And the agency, the State Board of Pharmacy, has a rule on patient profiles, which is exactly what the plaintiff is describing here. And they tied the rule to a valid prescription. They did not tie it to anything coming before that. And that's why I say this is a significant legal consequence.
Counsel, before, I know you're almost out of time. When we were presenting, and I can ask Attorney St. John this as well, was there any evidence that you were aware of that whenever the plaintiff approached the pharmacy clerk that he had any bandages or anything on his fingers?
I don't remember any evidence to that effect. He probably had a bandage on his finger, Judge Carr, but I'm speculating.
Well, that's what I was wondering, and how noticeable it was, and so forth. What type, etc.
It would be purely speculating. No party has called out at any point any testimony to that effect in any brief. So I just and the plaintiffs have not argued that his condition was observable, manifest, or anything along those lines. I may be out already.
You've got about a minute and 30 seconds.
Right.
So.
The point I would like to make about the regulation of this industry, Your Honors, is that when the Board of Pharmacy, has a regulation on patient profiles, and it's tied to the receipt of a valid prescription, I would respectfully suggest that courts ought to be wary of extending what the policymakers have done when they have acted in an area. I do not suggest that courts could not do that simply because the agency has acted in this area, but I would suggest it's an area where an awful lot of caution ought to be exercised when the agency has acted in this very area. And that's because, the policymakers are, for whatever the faults and foibles of other branches of government, the policymakers can think about these things and consider issues in a broader perspective than we can on a single record in what is undoubtedly a tragic set of circumstances, but without the broader perspective of the impact of this new first in the nation duty on a wider population. So
thank you very much. Your time is up, but thank you for that argument. 3 minutes for the rebuttal. Go ahead, Attorney St. John.
Thank you, Your Honor. I should probably begin by rebutting the proposition that the court shouldn't recognize a duty because the agency has already acted in this area. And I think that that's not what the agency has done, or at least not in the way that Counsel for Walmart suggests. The patient profile regulation or a code provision is geared towards getting information for the easy access and retrieval of patient information. The language for those regarding those patients who have received prescriptions from the pharmacy, I don't think that the administrators were thinking about, okay, so who is this duty owed to? It's basically to kind of to tie off, why do we have a patient profile system in the first place? And again, there is going to be a prescription here. So how do you satisfy this obligation to have a patient profile if you don't get the information when the man presents? And let me segue
Well,
to
Counsel, let me interrupt. I guess their argument would be you don't have that duty because there's no prescription there. So therefore you would get that information when the customer comes back to get his prescription.
right, and that puts the whole burden on the customer. And that I need to go back to this comparative fault proposition because I absolutely disagree with counsel from Walmart that we don't make tort duties this way. Well, granted, we don't start by thinking comparative fault, but we do start by thinking, among other things, about this public policy question of who is better suited. And the question of who is better suited to follow up is kind of fine and dandy when you're talking about contributory negligence being a complete bar. But in this era, we're talking about burdens being shared. And the pharmacy, and it's such an important point here that the pharmacy already has a system that can't be overlooked because they're already doing it. Patient profiles are already required, and the expert has testified that this is how the industry works. So to say that this is some kind of a burden, there are 6 people in line ahead of him, what's a poor pharmacy tech to do? Well, I'll tell you what, their employer says you're supposed to get him down to have the profile built.
So does that create an issue of fact in this case in your mind? Genuine issue of fact in this case?
I think there's an issue of fact as to whether the duty has been breached, but I do think that this court can recognize that there is a sufficient, special, or definite relationship between this kind of customer and the pharmacy to give rise to an obligation. It's a limited obligation to get the information to enable the individual to let them know when the prescription is in. And beyond that, then, whether it's breached, whether it's a proximate cause, and the apportionment of fault, those are all questions that will go to a jury. And interestingly, in this case,
I'll let you finish this answer, but your time is up, but go ahead and finish.
If this court reverses, then we're going to go to trial against basically 3. There will be 3 parties whose fault will be considered. There will be the medical care provider, the pharmacy, and Mr. Perez Herrera. And at that point, there are numerous questions of fact as to who bears responsibility and in what amount. And that's how the system should work. So we would respectfully ask that this court reverse and remand.
Very good. I want to thank you both for excellent arguments here this morning. The court will take the matter under advisement. We'll issue a decision in due course and certainly will mail each of you copies of that decision. The decisions are also, the opinions I should say, are also posted on the Supreme Court of Ohio's website. Yours was our only argument today and it was a good one. So thank you both for doing a great job. The court will next convene on Thursday, February 17th to hear further oral arguments. But on behalf of Judge Sutton and Judge Carr, we want to thank you again.
Thank you, Your Honor.
Your Honor.
Thank you.